If you look at again the time limit part of it, again, for whatever reasons the lawmakers have made, both of us have worked in the law making in the central government, each tax law has its own time limit. Excise law provided for 1 year and the 5 year as the case may be. But in order to invoke the extended period of demand, you need to make out clearly the grounds for invoking the extended period. This becomes very important. It's more, though it is on the part of the notice issuing authority. As an adjudicator, you need to address the objections or the submissions made in defense against the invoking of the extended period. You need to record a finding on that very clearly, keeping in mind the legal provisions and the factual matrix of it. For example, in the Customs Act, the timeline for that one is the timeline for issue of the notices. The other thing what we have to also keep it in mind is the timeline for completion of the adjudication. This is very, very important, and all of us need to keep it in mind as an adjudicator. Wherever the law mandates that you need to pass an order within this prescribed time limit, you need to pass. The most stringent provision in this part of the timeline for completion of adjudication, you will find it in the GST law. There is a deemed closure proceedings in the GST law, what has been built into. In terms of the normal proceedings, where you are not invoking section 74, your demand order has to be passed within 3 years from the due date of filing annual return or the date on which erroneous refund has been sanctioned. Now mind you, wherever an annual return has been filed before the due date, the 3 years computation or the 5 years computation will kick in from the date of filing annual return if it has happened prior to the due date. Be watchful of that. It's not that the due date of filing the annual return is the 3 years computation period. It is the actual date of filing of return if that has happened prior to the due date. If the annual return has not been filed or it has been filed on the last date, take that as the due date for computation of 3 years period. And the law also says in GST that if you don't pass an order, it shall be deemed to be close to the benefit of the taxpayer. The same provision exists in 74. For 5 years also the same, if you are passing an order, it has to be passed within 5 years. And we have number of cases already in the GST where our officers were struggling as on, I remember that it was on 31st December or so, 2023, I think the DRC, some of them have uploaded the DRC 07 and passed an order, but the portal did not get reflected. Somebody has already gone to a court of law and said that the order did not get passed on that due date, and therefore it becomes null and void, and courts have given some interim stay. Now what happens in GST is that everything is very transparent. Rule 142 provides for you the mechanism from where the DRC 1 to DRC 08 you have to pass at different stages, and it has to be all uploaded in the portal in a particular manner. So you have to be extremely careful in adhering to the timelines, otherwise the entire proceedings can be called into question and it can be frustrated. In case of Customs Act, if you look at the timeline for completion of the adjudication, it's slightly more flexible. That the timeline for completing adjudication, the law says that as far as possible in normal cases it should be 6 months. In case of an extended period demand, it should be 1 year. So it's the word used fortunately for us in that section 28 or for that matter 122 or for that matters. The customs provision is that it should be 6 months in the normal case and 1 year in the case of extended period as far as possible. The wordings used in excise law is that it is 1 year for normal cases and 6 months in the normal cases and 2 years for the extended period. Again, the word used is as far as possible. So there is certain amount of leeway for an adjudicator and get this passed within that. In the Customs Act in 2018, an amendment was carried out to the provisions of section 28.4 and 28.3, in which it has been provided that in case if an adjudication is not completed in the normal case within 6 months, or for that matter 2 years in the case of suppression willful misdemeanor cases, the period for completing the adjudication can be extended by an officer senior to the adjudicating officer to a max of 6 months or 1 year as the case may be of suppression, non-suppression cases. And beyond this extended period, the proceedings shall be deemed to have been concluded. Now, in customs law, there is a little more comfort than the GST law that the deemed closure will not happen before the timeline expiring the 6 months in normal period and the 1 year in the extended period can be extended technically for 6 more months and 1 more year for the extended period by an officer of the senior rank for reasons to be recorded in writing, for the reason that the adjudicating officer was prevented from completing the adjudication because it could be a non-cooperation of the taxpayer or it could be the voluminous work what some of you discussed about it. Now, in excise law, there is no such conclusion. There is no extension of time. It's only prescriptive. 6 months within which you have to pass a normal period order and up to 2 years in suppression cases you can pass. If you do not pass within that, there is no prejudice to the revenue. The department is still at liberty to adjudicate on a subsequent date. In Customs Act, it is a 6 months and 1 year, extendable by 6 months, another 12 months, beyond which it will be a deemed closure. In GST law, there is a hard lock. 3 years for the normal period and 5 years for the extended period, beyond which you don't get any benefit of extension. Now, in the proposed amendment, you are all aware on this, on 53rd GST Council meeting, which concluded on last Saturday, there is a proposal to amend the provisions of section 73 and 74. As per the press release, what has been released after the post GST Council meeting, you can all refer to that. There is a proposal to align the time limit for issue of notices for both normal and extended period demand. What do I mean that? The time limit for issue of notice under 73 and 74 is proposed to be brought on uniform time limit. The second part of it, the press release also talks about the time limit for paying the taxes for precluding the issue of show cause notice. Today it is 30 days from the issue of the notice. A person can come forward and pay taxes, and in case of normal period, he can get the waiver of the penalty. In case of an extended period demand, he can pay the concessional rate of 25% penalty and square up the proceedings. So there is a proposal to increase it from 30 days to 60 days. Over and above that, the proposal in the GST Council meeting is to introduce a new section called Section 74A. Section 74A will merge the provisions of 73 and 74, have a common time limit for issue of show cause notice, and probably a common time limit or maybe a greater time limit for deciding an issue to impose a penalty or not to impose a penalty, and keep the difference within the same time limit for issue of notice and time limit for deciding the matter, probably in a graded manner, with only difference of imposition of penalty or non-imposition of penalty. So I think one of the panelists in the morning was mentioning that in our eagerness to protect the revenue demand, even when there is no suppression willful misstatement, we have a tendency to invoke the extended period by a default provision rather than go for a demand which otherwise would not have required an invocation of a longer period of demand. So by merging the time limit under section 74A, you will not have two different timelines coming for the assessment year 24-25 onwards. You will have one single provision. You will have one completion period by which you need to pass an order, and the timelines could be for issue of notice could be provided for in a manner. The details are to be seen in the finance bill when it is being proposed to be introduced to the parliament. Watch out for the space. When the amendment is being proposed for section 74A in the finance bill 2024, you will see exactly the nuances of it. How is the section 74A is getting worded? What are the futures of 73, 74 is going to be built into that? And do we look up at time for relaxation of extension of time for completion of the adjudication similar to the Customs Act, etc., etc.? We will see. You also, those of my office colleagues in the Central Tax Administration are also aware the Central Excise Act has been completely revamped. A draft proposed Central Excise Bill was put in the public domain for public consultation up to 26th of this month. In that, if you look at very carefully the demand provisions, what has been proposed is on par with, there is a complete merger of extended period demand and the normal period of demand into one single provision. And one single provision in the Central Excise Bill which has been introduced, which is the public domain. Please go through that very carefully. It says there will be a common time limit for issue of demand notice for suppression and non-suppression cases. And it also provides for certain powers for the senior officers to relax the time limit for completing the adjudication borrowing the principles what has been inbuilt in the customs law by which you 2018 amendment. And it also provides for a deemed closure beyond a particular time, what is there in the GST law. So probably the flavor of how probably the proposed amendments is coming through in the GST law by virtue of section 74A, you can glean some insight from leading into the draft amendments proposed in the newly revised central excise bill. So that would be the flavor. So this is the second part of the adjudication, what I'm talking about, the timelines within which you need to complete the adjudication order. The third important thing about the adjudication process is to understand the provisions in a little more detail. I talked about the jurisdiction with regard to the proper officer, the definition of adjudicating authority, and the different manners in which the adjudication powers can be conferred. One model was the central tax model of monetary limits. The other one could be the assignment model of the state tax administration. I also talked about the flavor with regard to what is the timeline within which you need to complete the adjudication proceedings, and if you don't do it, what would be the outcome of it by virtue of a deemed closure proceedings, and the variations between GST law, the customs law, and the excise law. And I've also given you some sort of an overview with regard to what is going to come pursuant to section 74A being introduced in the CGST SGST Act, and I've also given you an impression as to what has been already proposed in the central excise draft law. Right. Now let us take the next one. What is that in the law which we need to look at? More importantly, because I understand that in this workshop a lot of you are focusing on the GST law provisions. If you look at section 73, 73 talks about a determination. Now GST law, let us keep it in mind very clearly that, and this is more so for my colleagues from the State Department, that today GST is a self-assessed tax. In terms of section 59(6), the tax has to be self-assessed. An officer cannot do an administrative assessment, what most of the VAT laws provided for in the past, in the pre-GST era. Central taxes, whether it is central excise, customs, or for that matter service tax, has been self-assessed tax. At least central excise is there from 1996. Service tax, from the beginning it's self-assessed tax. And customs also is a self-assessed tax post 2017. Now, if the liability of the owners or the responsibility of a person who is liable to pay tax is on himself, on a self basis, so whatever has to be determined, whatever to be assessed, he has the owner's responsibility of assessing the tax. What does an assessment means? Correctness of the valuation, classification, rate of duty, applicability or otherwise of an exemption, full or part, etc., etc. Apply the exchange rate in respect of the customs, etc., and then arrive at the liability and defray it in the manner which has to be paid. This is in nutshell is assessment. In that overall process, there has to be a compliance to the overall law. For example, if you are talking about GST, he has to take the input as credit. Wherever the reversals has to be made, he has to do that. And whatever is eligible to be utilized, he should utilize it and defray the tax liability and file a return. These are all his obligations, and this is what we call as a self-assessed liability. And this is in the GST law linked to a liability return called 3B filed in persons to an outward supply statement in terms of GSTR 1 filed. So today we all are very clear in GST that the moment you file a GSTR 1, accepting the outward tax liability through a self-assessment, this can be automatically recovered in terms of section 75(12) without even resort to 73-74 notice. Let us be very clear about it. What has been self-assessed, there is no need for a determination. Determination kicks into in terms of powers conferred under 73 and 74. Now, when does the determination comes? Is very important. Before I get into that delving, let me get into what are the situations in which you can do an assessment. An assessment under GST law is provided for only in 3 situations. 1, where a person is unregistered, and in pursuant to an investigation or any proceedings, you have come to a conclusion, whereas it appears to a proper officer. That's how section 73 starts. In case of an unregistered person, if there is a tax liability is said to have accrued, the determination route on 73-74 need not be gone through. You do an assessment proceedings. And how does an assessment happens? We issue an ASMT 10 They afterwards seek his response and pass a best judgment in terms of ASMT 13. In respect of the second category where assessment can be done is with regard to a stop filer. A stop filer or a non-filer is a person registered but consecutively failed to file 6 monthly returns or 2 quarterly returns. The moment that default happens, he becomes a non-filer, and you can, as an officer exercising the power, can pass a best judgment assessment order. Third, safeguard assessment, section 63, where it appears to the proper officer that in the interest of revenue, without waiting for passing an order in determination route under 73-74, he need to pass an order in the interest of revenue. But here the law mandates that such a safeguard assessment can be done only under the proper authorization of an officer of the rank of Joint Commissioner and above. No safeguard assessment can be done by an officer lower in rank than the Joint Commissioner. A Joint Commissioner's approval has to be taken and concurrence obtained in file before you do a safeguard assessment. So GST law provides for only 3 situations where you can do an assessment proceedings: unregistered person, non-filer, or a safeguard assessment. It can't be in any other case you can do an assessment. In all other cases, if you have to demand a tax, impose a penalty, it has to be through a determination route. And determination can come only by virtue of powers exercisable under section 73 or 74, read with section 291 of the Act. I hope I am making the point very, very clear. Now let us look at 73. 73 is basically talking about 5 scenarios. Tax not levied or short levied. This is the levy. Short paid or not paid, or erroneously refunded, or it could be for the purpose of recovering an input tax credit availed or utilized. These are the situations where you can go for a determination. Section 73 also talks about, in addition to determination of the tax, a penalty to be imposed. A penalty which could be prescribed in the law to the maximum limit, or the penalty prescribed by a specified limit, like in 73, you have a power to impose a penalty of only 10% or 10,000, whichever is higher. Whereas in 74, it can go up to 100%, but subject to some related relaxations. So any one of these 5 has to be necessarily involved. A lot of discussion has happened in the past, you must have heard about it. Can I impose a penalty under 73 or 122? Or should I invoke the power of 122 for imposition of penalty and only 73 for demanding tax? Or can I impose a penalty only under the excess of powers under 73? These are issues which has gone up to the High Court and deliberations have happened. Let us be very clear about it, because when we drafted the law, both of us, we were very clear that when we are talking about 73-74, a penalty arising on account of a determination where short levy, non-levy, or short paid, not paid, or erroneous refund, or for that matter ITC, a penalty can be a concomitant imposition exercising the power under 73 or 74 itself, and there is no need for separately invoking the power of 122 for imposition of penalty. And 122 penalty can be imposed on a person who may be not a taxable person. He could be a person who could be a transporter, a warehouse keeper, or could be a person who could have abetted or played a role with regard to those short payment, non-payment, erroneous availment of credit, etc., etc. A 122 could be basically looked upon from that point of view of a person who is liable to pay tax, but who is liable to pay a penalty, but not a person from whom a tax can be recovered. For example, we are talking about section 122(1)(b), introduced in the 2023 Finance Act. There is an imposition of penalty for an e-commerce operator. An e-commerce operator who is liable to recover the TCS if he is found to be faulted in not complying with the provisions of maintaining a proper account, producing records, or facilitating a seller who is committing an offense, or permitted to sell the goods from an e-commerce operator without registration, that is prior to October 2023, a penalty can be imposed on e-commerce operator. So those are the provisions under section 122 can impose penalty, but There is no preclusion from imposing a penalty under the provisions of 73 or 74 for any of those determination route. So this is first and fundamental. The important thing also we need to take care of when we read section 73. 73 talks about some of the provisions which are narrative in nature in a sequential manner. 73.2 talks about a clear-cut case of a statement. That means if a show cause notice has been issued for the previous period, giving detailed grounds as to why the demand has to be proposed to be confirmed, it's an allegation. The subsequent period, if the issues are the same, without issuing a detailed notice, a statement can be issued. A statement is nothing but a quantification of the tax liability for a particular tax period, which is following the period for which a detailed notice has been issued. You can go for a statement, and that statement is deemed to be a notice for legal purposes.